Welcome, Fed friends. Today we're going to talk about common law marriage and what that means for situations where people have been together for an extended period of time but have not legally gotten married. What we're really going to be looking at is what does the laws say a spouse is, and what benefits qualify for spouse and just under the common law spouse benefits. So laws say a spouse is, and what benefits qualify for spouse and just under the common law spouse benefits. So these are some notes that we provided to one of our advisors regarding the survivor benefit and insurable interest. And we've already done the research on some of this. So with Title V, what they consider a spouse, the definition of a spouse would be someone who is married to the employee for at least 9 months or more. And if less than 9 months, then the spouse would qualify to be considered a spouse if there was a child born of the marriage or out of the marriage. But if there was a child born between those two people, kind of they get in a car wreck or something like that, it's not kind of a, obviously because they just got old or whatever, they were sick and whatnot. So if the death was accidental and that was less than 9 months, the spouse would technically still qualify being considered the spouse for the survivor benefit. Okay, so we can find this in the code. This one is Cornell Law School. I just like how they have the law laid out. And so I searched Title V, and we'll go back in the code. This one is Cornell Law School. I just like how they have the law laid out. And so I searched Title V, and we'll go back a little bit. So search Title V, we went to insurance and annuities because of what qualifies for the insurance and the annuities. And survivor annuities, that's what I meant. It's under the survivor annuities, and then what does that define? So this is specific to survivor spouse annuities, and this is what a spouse is. And you can read here, this is the same thing as what we said before, right? Was married to, well, a widow. Widower obviously was married to the employee for at least 9 months. On that was the mother of issue was the mother of a child or the father of a child. And so that's what qualifies them. They talk about what a child is and then go into that. Obviously, OPM can have other information as well and be able to explain it fully. Here is, it has to be a documented marriage, right? So if the employee would still like to give a survivor benefit to their significant other, who is not technically their spouse, they can name them as an insurable interest. However, there are some considerations. A survivor benefit to their significant other, who is not technically their spouse, they can name them as an insurable interest. However, there are some considerations, but essentially this is who can be named as an insurable interest. Person who has a relationship with you, right? All of this has to be, if the person isn't one of these people, then there still needs to be, obviously, like we were saying, and the whole part of this insurable interest, right? Somebody has to be, has to be able to have some sort of interest in your life. And so the biggest kicker with this is, though, well, there's two actually. One is medical underwriting will need to be completed. So it says, and paying for the cost of any medical examination required to show you are in good health. A report of the medical examination should be included with your retirement application. So here's the thing. You can name an insurable interest, but you still have to prove that you're medically insurable, just like life insurance, right? So this may not be the best option for an employee to have somebody named or a significant other named under that. It might be, but one of the kickers is you have to prove that you are medically able to name an insurable interest. So a medical examination will have to be done, and your amount that you have to pay for this benefit is insane. Depending on, well, maybe not, depending on the age gap between you and the person you're naming, right? So I had a situation, their significant other was 20 years younger than them. So with that, if somebody is 20 years, let's see, the named person is 15, but less than 20 years younger. No, they are 20 years younger. So if the named person is 20 years, but less than 25 years younger, the retiree would have the reduction of 30% of their pension. Now, for a normal spousal survivor benefit, it's 5% or 10%, depending on how much you're leaving your spouse, or zero if you don't plan on leaving them anything. But if you want them to have at least 50%, which for the insurable interest, then your survivor will receive 50% of your pension. There is no other option here under the FERS program. So with that being said, you're paying 30% for them to get 50% of your pension, right? So that's the biggest kicker is the amount of money it takes to put into something out of your pension for them to only get a certain amount, right? So this is where it may not be worth it, or if you are going to be needing to have, an insurable interest named, you want your significant other to be able to participate in the health program, then maybe you have to do this. But why not just get married and pay a lot less too? I don't know. That's an individual decision or a couple decision rather, depending on how you look at that. But the idea is that you have the information now to really make informed decisions and see why it may or may not be worth it for you to name your significant other as an insurable interest. So those are the biggest kickers. One, you have to qualify medically, and you need to figure out where is that amount that you're going to pay if you are going to name them. Now, if you are going to name them an insurable interest, then they can still participate in the FEHB program, and FEHB will recognize your common law spouse as a spouse if certain things are applicable. One is your marriage has to be initiated in a state that recognizes common law marriage. And then you also have to provide some documentation as well to prove that you guys are commonly married, right? So one of those is your financials have to be together. People, refer to you guys as married, that sort of thing. A court or judgment initiating that or recognizing your marriage as a common law marriage. So that kind of stuff does need to be in place as well for FEHB to recognize your common law significant other as a spouse. Also, what they say here is that it has to be, or that you can find the list of those states that recognize common law marriage. So when you pull that link up, this is where it will bring you to, and you can see those states where the law applies, and there might be different time frames when some didn't recognize common marriage, but now they do. So you can go through that list, get onto some of those other statutes and things like that about what that looks like for you and your spouse. So does common law marriage apply to the federal government? Yes. How it is applied, again, is another question, right? And the answer is it depends. But the biggest thing is understanding what that looks like for you and your family and your significant other as you guys embark on the retirement planning journey and figuring out which option is going to be best for you both. Thank you so much for your time today, but that's all I have on common law marriage. Please, if you have any other questions or comments, let us know and we'll be able to help. Thank you.